If we could bring in the next group, then if I could introduce them. They're from the St. John Mental Health Court in New Brunswick. I'd like to introduce Judge Andrew Palmer from the Provincial Court of New Brunswick. His Honor Palmer graduated from the University of New Brunswick Law School in Fredericton, New Brunswick in May 1990 and was admitted to the Law Society of New Brunswick in June 1991. He practiced law in St. John, New Brunswick and Sussex, New Brunswick, maintaining a general practice from June 1991 until August 2014, when Judge Palmer was appointed to the Provincial Court of New Brunswick, sitting in St. John. In the fall of 2017, upon the announcement that there would be a specific docket in St. John Provincial Court to allow individuals who encounter the criminal justice system while dealing with mental health issues to be diverted from regular court proceedings, Judge Palmer assumed primary judicial responsibility for the operation of the St. John Mental Health Court. In addition to fulfilling the usual duties as a provincial court judge, he has continued to preside over the court to the present. Thank you, sir. And with you today, we have Crown Attorney Natasha Meier and Crown Attorney Ms. Logan, both from Public Prosecutions in New Brunswick. Thank you for being here.
All right. Thank you very much. Can you hear me okay?
Yes, sir.
All right. So again, my name is Andrew Palmer. I'm the judge assigned to the mental health court here in St. John. And I and you have the benefit of having Ms. Logan, Rebekah Logan, and Ms. Natasha Meier present with me today to speak to you about the St. John Mental Health Court. As Dan indicated, it was in the fall of 2017 that the provincial government announced that there'd be a specific docket assigned to the St. John Provincial Court with respect to mental health court. It was the second iteration of the mental health court in St. John, the first having been established by Judge Alfred Breen as a pilot project in 2000. And then it became a permanently established in St. John in 2003, and Judge Breen continued to maintain it until his retirement in 2010. After that, there wasn't much judicial interest in maintaining the docket, and it fell by the wayside until the province, I believe, recognized the benefit of the mental health court and reestablished it in 2017. Basically, and I don't want to prolong the talking more than is necessary, but basically what the court does is it recognizes that there are individuals that come into contact with the criminal justice system as a result of either an unaddressed or underaddressed mental health issue that caused or contributed to the commission of an offense. If that's recognized by one of the court participants, then they may make a referral to the mental health court, at which time we undertake an analysis to determine whether or not they would qualify. Essentially, there are three criteria that are required for mental health court. It's first, that there has to be a mental health issue that is connected to the commission of the offense, and there also has to be an acceptance responsibility of the commission, although not necessarily be it a guilty plea, but just an acknowledgement that that they did commit the offense that is alleged. Presently, our team consists of myself as a judge, Ms. Logan and Ms. Meier as the primary Crown Counsel assigned to the mental health court. We have a dedicated duty counsel, dedicated social worker and nurse, as well as a dedicated probation officer. And we meet bi-weekly to discuss matters that are occurring in our court. Previously, we had the benefit of a psychiatrist, that was assigned to the court, but he's on sabbatical, and I don't expect that he'll be coming back, and he hasn't been replaced. And also, we've lost the benefit of having a clinical coordinator who was integral in coordinating our efforts with community partners and in ensuring that the needs that were seen within our clients were sought to be addressed within the community. That, in a nutshell, is the mental health court, but the nuts and bolts of it are going to be addressed by Ms. Meier and Ms. Logan.
So in our mental health court, there's basically kind of 3 different parts to it. So I'm going to talk about the first part, which is the referral and eligibility. New Brunswick is a little different than some of the other provinces because we're what we'd call a Crown approval province. So a Crown prosecutor reviews every charge before it gets laid by the police, and we basically run through our assessment of whether there's a reasonable prospect of conviction, and then if there is, if it's in the public interest to proceed with that charge. So there's a lot of vetting that happens there. And a big part of that process as well is what we're seeing is Crowns in our office are identifying people very early who pass those 2 thresholds, but who may qualify for mental health court, and they'll write it right on the file. Those files would then go into our plea court, which we call current court. And so those people would be identified at a very early stage as being a possible candidate, and if they wish to come over to the court. And so that's done by a Crown. Other than that, we accept referrals basically from anybody. A lot of times it's duty counsel and speaking with the clients, identifying potential candidates, and sometimes it's coming from the judges themselves. And it can happen at any stage of the proceeding prior to sentencing. We have had people come over when it's the day of their trial, and these issues have arisen and they would like to be referred over. Sometimes it happens at the bail stage or first appearance. So there's really no set route that one needs to take. There are multiple opportunities to come over and then be assessed for mental health court. In our mental health court, you don't have to come with a mental health diagnosis. It's certainly helpful to us, especially now that we don't have a psychiatrist on the team, but it's not required. And we work to help people get that information. And as Judge Palmer said, there needs to be an ability to take some sort of responsibility, even if it's not with a guilty plea. So those would be kind of the main things we would be thinking about in terms of eligibility and people being referred over.
So I'm going to go through the next 2 parts, which is the assessment phase for an individual who has been referred over to mental health court, and then what we work through in looking through those individuals and that assessment that's been done to determine whether they are eligible to participate. So because individuals can come over without a diagnosis, that's kind of our first look at these individuals. We have participants who come over sign consents at their very first appearance in mental health court. That gives us the ability to have social workers look through any past mental health files that they have. So if they've had past interactions with the mental health clinic or anything like that, and as well as justice to look into past files as well. So for the assessment portion, a social worker meets with all of the participants and does an initial intake. So looking through if there is that history, trying to look if there has been a diagnosis. And then when we did have a forensic psychiatrist that we had at the table, all the participants would also meet with a psychiatrist to formalize a diagnosis and also to look at the topic of medication and whether that's required or not. Where we don't currently have a psychiatrist on our team, we have one made available to us for situations where we really feel like it's necessary, but the social worker really does a lot of the heavy lifting right now in terms of looking at what information there is out there and going through the current symptoms and issues an individual is facing. So outside of looking at the confirmation of any mental health diagnosis, another thing that happens at the assessment phase from the Crown side is looking at the charges that are coming over with the potential participant and determining a Crown's position on those charges. So if it's a situation where jail is absolutely necessary, we can't get around it, or there's a mandatory minimum or there's something at play, then at that point in time, the Crown will voice their opinion that this doesn't look like it's appropriate, even though someone may have a mental health issue. Also look at compliance issues. So those are in cases where perhaps somebody does have a pretty lengthy history with mental health. Are those individuals actively participating in the treatment that they're already a part of, or are people chasing them for for compliance, things like that. So if someone, as I'm sure everyone's aware, mental health court, being a therapeutic court, requires a lot more participation from individuals. So we want to make sure that people are on board and will actually engage. Once the assessment phase is complete, the whole team gets together. So Judge Palmer, the Crown, Duty Counsel, the social worker, probation officer. We'd have a roundtable discussion where we all kind of talk openly about what we think, about those eligibility criteria. Is there, number one, is there a mental health issue? Number two, is there that nexus between the mental health issue and the offense? There are, I should say too, in terms of eligibility criteria, when we're all talking, there are, most disorders are included and we would consider for participation. And we also consider concurrent disorders. So if there's addictions as well as another, a mood disorder, schizophrenia, something like that. If it's purely addiction, unfortunately, we're not set up to deal with just that. We just don't have the resources here to do that. But concurrent, certainly we do. And some personality disorders are accepted. That's a case-by-case basis. And again, that comes down to resources. So once the disorder meets the criteria, the nexus meets, individuals willing to take responsibility, then we determine this person looks like they're a good fit, and then they'll continue on into the program phase as long as they also want to participate. So that takes us into the treatment/monitoring phase of the program.
So I'll speak briefly about that. That's kind of the final phase of our program. And generally what we do when people are accepted to the mental health court is Rebekah and I would draw up in consultation with the team and duty counsel kind of a contract. We call it a contract of expectations for the clients who are coming to mental health court, so they know upfront exactly what we're hoping to see them do and what kind of progress we're looking for. And included in that would be the Crown's position. So if you do kind of XYZ and it goes well, this is what the Crown would seek at the end of the process. So that can be anything from a withdrawal of charges to peace bonds to discharges, anything non-custodial essentially. And so the treatment plans that we have are different for every person. They're really tailored to the issues that the clients are facing. Sometimes it's a harm reduction model of reducing their substance use in coordination with going to counseling. Sometimes it's including detox. We had someone recently who completed some domestic violence specific counseling. So we really try to meet people where they are and address their specific needs and make that part of the contract that works for them. Generally, we meet as a court every 2 weeks. So we try to use the appearances kind of as a carrot and a stick. So if you're someone who's not really complying very well and things are falling off the rails, well, then you'll likely be coming to see us every 2 weeks until we can make sure you're engaging with your services and doing what you're supposed to do. If you're really doing well in the community and you're doing the expectations, then you can come back in many, many weeks, sometimes months. We try to be flexible with people who are in school and working. So we do try to accommodate the clients as best we can. In terms of length of time with the program, it really does depend on the person. Sometimes it's a very narrow issue. Often it might just be a medication issue. So we just want to see a period of stability for that person. And once they're back to being stable and they kind of have their resources lined back up again, they can be finished with the court. But in general, we're often staying with people for a year to 18 months, and then hopefully having kind of a graduation for them at the end. In terms of the role of victim, we're trying to get, if there is going to be a requirement for a guilty plea, we're trying to get that early in the process so that we can get victim impact statements. They can be read if they wish to come and engage with the court. And then we can kind of move forward as a benefit to the client and mental health court too, not having to discuss the facts at the end when they've done so well in the process. So that's kind of how our program phase works.
In terms of, I know we don't have a whole lot of time left, so I'll try to be brief. Similar to what Daniel indicated from the Toronto court, in terms of best practices, it's critical really to engage your community partners. Unfortunately, we're at a bit of a disadvantage right now with the court because we've lost, it's been a period of time since we've had really a dedicated clinical coordinator that would coordinate issues between the court and community partners to make sure that our clients are receiving services in the community that they need in order to recover from whatever the issue is that they're presently addressing. And we really miss it. So it's critical that there be that communication between the court and the community partners. The other thing too is, even though we've lost a clinical coordinator, we continue to have members of the team that are fully engaged and committed to the clients and the purposes of the mental health court. It's very rare that you see that there is someone that just doesn't fit within that parameter, but when it does happen, it's glaringly obvious. And like I said, we're fortunate that we have in the past and we continue to have in the past, including Natasha and Rebekah, fully engaged and committed partners to trying to achieve the best possible result for our clients. And I'm glad to say also it's necessary that you work together as a team. There's no one voice that supersedes anyone else, and you work collaboratively, and everyone's input is valued and sought after, and as many voices as possible that can be heard around the table are sought to be achieved. So that in a nutshell, I don't know if there's anything else you would identify, but
No, I don't think so.
that in a nutshell is what I see as, from our perspective at least, what's necessary in order to make a successful model. Anyway, I know there isn't a whole lot of time, but we're certainly prepared to address any questions that anyone may have.
I'm not sure if Keisha will find a couple questions there or not, but I can tell you that it's really heartening, and I have the greatest hopes for your continuation of your wonderful court. Natasha, Rebekah, in your honor, thank you for coming today and for all the work you've done. I know that in St. Thomas, we cycle through different people being around and the core. And quite often the core is a smaller group like you guys, but it's that core that does all the work from the beginning to the end. And in the future, you guys are going to still be there. And because you have that core, this is going to continue and all them people are going to get help. So don't worry about those extras. They'll all come. Just keep it going because it's life-saving and it's beautiful to see. And thank you for the encouragement of being here.
All right. Well, thank you for your comments.
Thank you. Judge Palmer and prosecutors Rebekah and Natasha, there's one question here in the chat. So where there's a concurrent disorder of substance abuse, does the contract of expectations require urine screens?
Yes.
Yeah, quite frequently, yes. So and when we know that there is a concurrent issue with respect to drug use and the mental health issue, we'll get a urine screen very early in the process, and they will be screened regularly. And it's set out in the contract of expectations, and it's set out to them very early. This is what we expect you to do. And we know you're not going to be able to address it immediately overnight, but we want you to try to address it to minimize the risk and continue to address it going forward. So, and they know, our clients know that if they may be periodically subject to providing a urine screen on their appearance in court.
Thank you, Judge Palmer.
Thank you.
Thank you very much.